So, good morning. I'm going to be talking this morning about pre-appointment liquidations as possibly an alternative to administration pre-packs. This is a subject which has come up in conversation where, as you know, I've been looking for appointments as evaluator, and I've had a few appointments and a few discussions with people about the alternatives to acting as an evaluator. And there have been some interesting discussions that we've had in particular about liquidation sales rather than administration sales, and whether it would make sense to be selling the business pre or post appointment of the liquidator. So my themes for this morning is I'm going to start with a bit of history to look at the way that we used to do insolvency sales of going concerns and what has changed over time and why. I'll move on to look at what the current options are for going concerns in the main. I'll then be looking at the twilight zone, where it starts, what the issues are in the twilight zone, and looking at that particularly from the perspective of what directors need to be thinking about if they're looking at selling their business as a going concern to a connected party, and issues advising insolvency practitioners.
Is that too loud?
And then I'll be finishing off by looking at some of the commercial issues that may be relevant to all of this. So I've divided the history into four phases. Ancient prehistory, which is basically before 1986, the Insolvency Act. The dawn of civilization, which is post-Insolvency Act 1986, and the new procedures, the then new procedures introduced by it. The start of what I will call the modern era, which was Schedule B1 administrations as brought in by the Enterprise Act, and then finishing off to look at the latest developments, particularly the Phoenix pre-pack regulations. So, looking at ancient prehistory before the Insolvency Act 1986, there were essentially just two main statutory procedures at that time. There were liquidations, and that was, of course, a Companies Act procedure, and it was very much geared towards the meeting of creditors. That was a necessary part of all liquidations. And there were also receiverships as well, and they were largely unregulated, very little statute about them. And also, for the brave, there were also informal arrangements, and I've seen these described as being where an insolvency practitioner would herd the main creditors into a room, lock the door, and then shout at them until they had agreed more or less with whatever it was that seemed to be necessary to get the business to survive. The issues before the Insolvency Act were really then that if a receivership was not possible, it was going to have to be a liquidation. And the choice for the prospective liquidator then was whether to sell the assets before they were appointed or whether to get themselves appointed and then sell. And the issues for them, if they were thinking about selling after they were appointed, was the notice that was sent out to the creditors of the meeting might itself do further damage to the struggling business. And also there was the risk that at the Section 98 meeting, the creditors might decide to appoint a different liquidator. And the issues there was that from the point of view of the insolvency practitioner, that might mean that they don't get the job. From the point of view of the strategy for the business, it might result in the sale being at least delayed and possibly in a completely different strategy. Perhaps the sale just might not succeed at all. Pre-appointment sales were very often preferred because it made the liquidator's task rather easier. The liquidator would simply be handed a bank account with the sale proceeds in it rather than having to deal with the business assets themselves. But it did take fairly careful control of the directors in the pre-appointment phase when the prospective liquidator had no statutory powers to do very much. Then we come to what we could regard as the dawn of civilization and the Insolvency Act 1986, a newly regulated profession, and at the same time some new procedures. The main new procedures relevant here, of course, were administration orders, as they then were, administrative receivership, which was not hugely different from receiverships as they had been before, and voluntary arrangements, of course. In the early days of administration orders, of course, there was initially uncertainty about whether the administrators even had power to sell the business before they had circulated their proposals to creditors and had them approved. And the other issue was that administration orders were a very court-intensive process, and particularly if you were thinking about a pre-pack sale, that would mean that the pre-pack would itself come under judicial scrutiny because it would have to be disclosed as part of the appointment process. And so it would have to be very tidily wrapped, and would have to be a proposal that was going to survive judicial scrutiny at that stage, which added considerably to the costs. And administration orders soon came to be thought of as being, well, actually, great idea, but far too expensive, particularly for smaller companies. And again, just on a historical note, it's worth mentioning that the Cork report in 1982, which led to the Insolvency Act, in that they noted that phoenixes were then a continuing issue of public concern. They have been, they always will be for as long as there are corporate insolvencies. Then we come to what I would regard as the start of the modern era with the Enterprise Act. A couple of years earlier, we'd had the wholly unsuccessful Schedule A1 moratorium leading to a company voluntary arrangement. The Enterprise Act seemed a brave attempt to do something similar for administrations. It was actually, as you know, hugely successful. It allowed for administrations without the need for a court order. And we soon had the rise of administration pre-packs, which were an unanticipated consequence. And of course, without the need for judges to look at the proposed administration before you were appointed, the pre-pack sale did not need to be as fully developed or quite as tidy at the time when you were appointed and when it was implemented as perhaps might have been the case if you were going for an administration order. This, of course, led then to lack of creditor oversight, lack of creditor involvement, and the fact that you could sell the business and it would be 8 weeks before the creditors would even have your official statement on it in the proposals. It's always difficult in administrations for creditors to appoint a different insolvency practitioner if they're not happy with the strategy or the way that the strategy is being implemented. And I'm not going to bother to even begin to list the numerous government and regulatory initiatives that we've had, which led to most recently the pre-pack pool, and which has now been put on a statutory footing with the Phoenix pre-pack regulations. And as you know, those state that the purchaser will have to get either approval from creditors or an evaluator's report if the buyer is a connected party buying from an administrator within 8 weeks of their appointment. And that applies to pretty well all sales to connected parties in the first 8 weeks following appointment, unless the assets being sold are not a substantial part of the assets of the company in administration. And of course, these regulations, we're already seeing that there are additional consequences to them in terms of extra costs of compliance, both direct and indirect costs. The fact that the administrator will perhaps have to polish and develop their proposals and their SIP 16 report to a greater degree when the regulations apply than they previously would have had to have done. And of course, with this is additional complexity and delay that's been added into the process. So let's move on from the history to look at the options for going concerns. And the two main options that we've got, if the business itself, if the company itself has a decent chance of survival, of course, a voluntary arrangement. And now we also have to consider the Part 26A reconstruction, which I think is probably appropriate only to the more complex and larger cases. If the company is unlikely to survive, but the business can, then your options are firstly to consider trading the business in administration and sell it. And I think you should always note your reasons for ruling that out. It's obviously going to be in very few cases where that is going to be viable. There's the option of a pre-pack administration sale, or there's the two options of liquidation, of essentially having the directors to sell pre-appointment and then liquidate, or for you to take possession of the assets as liquidator and then sell them immediately on your appointment. The issues, as always, for a going concern in an insolvency are firstly funding and how it's going to keep trading up until the point of your appointment, and if there's going to be any trading post-appointment beyond that point as well. And even if the trading is cash positive, there may be peaks and troughs in the expected cash flow that don't match the generation of cash. Another issue, of course, is confidence of key suppliers, key customers, key employees, particularly now in the 21st century, where businesses so rarely own much in the way of tangible assets, and so many businesses are built entirely on the relationship they've got with suppliers, customers, and employees, and a big disruption to any one of those relationships can have a very serious consequence for the business. And then secondly, there is the disruption shock involved, and the fact that the company is going to be sold is itself going to create a disruption shock. If there is going to be a pre-sale appointment and the insolvency practitioner is going to effectively take possession of the business and trade it, you've actually got two shocks. The first one is on your appointment and the effect that has on trading, and then the second one is then on the sale. So that can be undesirable. So let's have a look at the twilight zone now, and this is really the period when the viability of the business is failing. And for our purposes, we'll treat this as starting when the insolvency practitioner is first consulted, and more exactly, the point at which your engagement letter is signed. And you'll be working with the directors then on the strategy for selling the business as a going concern. With them, you'll be looking at the options for selling to a third party as well as the connected party sale. As long as the connected party sale is looking viable, then the directors will be working on promoting the new company, developing it to the point where it can take over the business, and they'll be negotiating the terms of the purchase with you. And once that is agreed, and the basis for the purchase is in place, then you can start the appointment process. And if it's a pre-pack administration, of course, the sale will take place immediately after you are appointed. If we're looking at a pre-liquidation sale, then the sale is likely to complete as you are starting the appointment process. Now, the date of the sale is likely to be the same whichever process you're following, but it's just that the insolvency appointment itself will be on a different date. The appointment process will take longer for a voluntary liquidation than an administration in most cases. So you'd find the pre-liquidation sale and an administration pre-pack, you're looking at a very similar completion date for both of them. A sale by a liquidator will be at least a few days later. And of course, if you've got a qualifying floating charge and you need to give notice of intention to appoint, that can slow down the process as well. Now, looking at this from the perspective of the director and what they're going to be thinking about, there are no objective ethical issues that apply to company directors. And by that I mean there is no regulator of company directors. They're not at risk of being struck off or disciplined, so they don't need to be concerned about those issues. So it really is just the legal duties on them that they're going to be thinking about. And I've put these into three categories: the Companies Act duties, the Insolvency Act and disqualification risks, and as a category of its own, Section 216 compliance in terms of the reuse of the company name. And even in the twilight zone, even when insolvency is inevitable, the directors do still owe duties to the company that are owed to the shareholders. And in particular, if there is to be a substantial disposal of assets to a connected party, that needs shareholder approval in both companies to make sure that it is a valid and binding transaction. There are also duties to the company which are complied with in terms of duties to the board, and this essentially boils down to board minutes where the connected party transactions are formally disclosed and approved by the board. And again, that would be in both the company that's going into liquidation and the purchaser. And then there are Companies Act duties which are owed to the company, again, as they all are, but which in the twilight zone are then properly regarded as being duties where the interests of the creditors are paramount rather than the interests of the shareholders being paramount. And these are very much analogous to the Insolvency Act duties about wrongful trading, fraudulent trading, preferences and transactions and undervalue, but they're expressed in terms of directors being obliged to promote the success of the company, directors having to show independent skill and having to use reasonable care, skill and diligence. And the Insolvency Act duties, which again have disqualification consequences if they're not complied with. Main ones are these, and they are to some extent not wholly compatible with each other. So there is the obligation not to make commitments that the company will not be able to honour, and the risk of breach there is a claim for fraudulent trading. The duty not to allow the debt to creditors to increase, where the risk would be a claim for wrongful trading. The obligation on directors that they should not be paying some creditors but not others, and that's enforced through the rules on preferences, and the rules, of course, to get fair value for assets enforced by the undervalued transactions rules. Section 216 is important in all of this, and as you know, it is a prohibition on the director of the old company that they cannot be involved in the future with a business that is continuing to use the trading name of the insolvent company, and that ban lasts for 5 years. Now, the trigger for Section 216, of course, is the liquidation procedure. It's not triggered by administration, so in some cases that might actually swing the balance, certainly from the director's point of view, towards wanting administration rather than liquidation. There are, of course, 3 common exemptions to the Section 216 ban. The first one is the notice procedure, sending notice to creditors and publishing them in the Gazette. But that will only work where the business was actually sold by a liquidator, or another office holder. So if you've got a pre-liquidation sale by the company, they cannot use that Section 216 exemption. Now, I have seen cases where this has been fudged, and we've had the purchaser effectively taking possession of the business on a license arrangement pre-appointment, and there has then been a pre-packaged sale agreement to complete the transfer of ownership of the assets immediately the liquidator is appointed. I think that's not wholly satisfactory from the director's point of view, and it does expose them to some risk from Section 216 in the future, so it's not ideal. Second exemption, of course, is through a court order, and the third one is if the purchasing company has been using the trading name actively and legitimately for at least 12 months already, and it's good news when you can comply with that exemption, but it doesn't often come up. So the essence behind Section 216, if you're looking at a pre-liquidation sale, is that the safe approach for directors to take is that either the new company will have to use a different trading name, or if it is essential for the new company to be using the same trading name, then the best approach is to get a court order for permission to do that. Other issues for the director is there's going to be Companies Act compliance paperwork in terms of board minutes and shareholder resolutions in both companies to approve the transaction. And I suppose the essence of the Insolvency Act obligations on them is that the law is encouraging directors to appoint an insolvency practitioner at the earliest opportunity on the decline curve to document the plan for coming out of the crisis that the company is in, by whatever means that may be, and the director should be monitoring and recording their decisions and their progress against their plans. And Section 216 will require, if it's a pre-appointment sale, either a name change for the business or a court order to approve the use of the name. So let's look at the issues for you as the advising insolvency practitioner. I've divided these into three categories. There's advisory, ethical, and job security. And in terms of advisory, well, I've already covered the issues for directors that you're going to need to be advising the company on. And I'll talk in a few minutes on the commercial issues that you're going to be thinking about. So let's look at the ethical. Let's look at the job security next, because that's probably the crucial one. And of course, there's the Rule 614 procedure that we've got is designed to allow the creditors their choice of liquidator if they want to. And the issues around Rule 614 is the circulation of the statement of affairs and the list of creditors in advance of the decision to appoint the liquidator. And if you have an insolvency practitioner who has creditor support, to get them appointed in place of the advising insolvency practitioner, then by putting in a rule of 10 objection to the appointment, you kick the process out to a meeting of creditors, and you've then got additional time to consider the statement of affairs, the list of creditors, and to try and drum up additional support to change the proposed liquidator for this. And under that procedure, there will then be a meeting of creditors. For the ethical issues, you'll need to be thinking about the self-review threat and the advocacy threat, both of which really are arising out of the potential conflicts of interest which themselves develop from the relationship that you have got as an advisor to the company as it's heading up to the formal appointment, and then the change in the relationship you've got once you have been appointed as liquidator. And I'll say a few words about mitigating those ethical threats. So this is a compare and contrast slide. I've tried not to have very many of these this morning, but this is where if you're selling as administrator, you of course have to report on the sale and justify it to the creditors. That's perhaps easier for you if you've got an evaluator reporting on it and confirming that they think that this is the correct strategy as well. And of course, you will have been selling as agent for the company. You will have had legal authority to sell the assets of the company. The risk of compromise comes from the pre-appointment advice that you will have given to the company through its director. And the director, of course, will be involved with both the new company, the purchaser, as well as the company that's becoming insolvent. And the director may not be quite as diligent at assessing which hat they are wearing at the time when they're receiving advice from you. In a pre-liquidation sale, you're similarly going to have to report on the sale to the creditors, but you will not be a party to the sale, so you will be reporting on it from the position of objectivity and impartiality, and therefore the risk of compromise again comes from the pre-appointment advice that you gave in much the same way, and your involvement with developing the strategy. So it's going to be very important in mitigating these ethical issues for you to make sure you have advised you've identified who you're advising pre-appointment, whether it is the company through its directors, which it almost certainly will be, and to rule out giving advice to the directors personally in their capacity as directors of the insolvent company, and certainly in their capacity as directors of the new company. And you should be steering them quite directly towards independent advice, both for the buyer and perhaps also for the directors as well. And you perhaps also ought to be thinking about whether you should be getting separate valuations for yourself from the valuations that the directors are getting, and whether your valuation is one that you should get pre-appointment or post-appointment as liquidator. So let's have a quick look at the commercial issues, and I've got these 5 jotted down. Timing of the transaction, funding the transaction, the issues around trading itself, business resilience, the effect that all of this will have on the survivability of the business, and employees and their rights under TUPE and what that means. So in terms of the timing of it all and the speed of appointment, because speed is always going to be important in these cases, the completion date for a pre-packaged administration sale or a pre-liquidation sale are probably going to be very, very similar, but a post-liquidation sale will be slower to conclude. And also, you should be thinking about whether there is a qualifying floating charge here and how much the need to give notice to the debenture holder will slow down the appointment. You can conclude the sale before formal notices go out to creditors, and thus minimize the shock. If it's being dealt with either as a pre-packaged administration or a pre-liquidation sale. But again, pre-liquidation sale, do make sure that the new company has made an informed decision about the implications on it of Section 216 and the implications for its directors. As always with a going concern, there is the issue as to whether the business should actually still be trading at all. And if it is continuing to trade up to the point of appointment, how is it being funded at present and how are creditors being protected? And you'll also need to be aware of the funding issues for the transactional costs. If it's a pre-packaged administration, the cost of an evaluator and the indirect costs of that, the costs of valuations, and the costs of independent advice, both for the new company and perhaps also for the directors. In terms of business resilience, there's questions about whether the business can survive a phoenix and whether it is actually your job to advise on that. And if it's not your job to do that, then whose job is it? Under SIP 16, that's something you should be advising on, and it's something if I'm acting as an evaluator, I would need to see some commentary on that as well. There's the question of whether the business can survive a period of shutdown. And of course, at present, we're approaching Christmas period when many businesses will be shut down anyway. And that might be a useful time to actually complete a sale with minimum disruption. And that can be done as a sale by a liquidator. Issues, of course, then about the fact that you'll be sending out notices of appointment at around the time when everybody is on holiday anyway, which is not ideal. And you would also need to be thinking, well, you need to be looking at what the directors are thinking about as to whether the business can survive a name change. In terms of TUPE issues, look at the plans for restructuring the workforce, and TUPE is less of a risk for the buyer, of course, if the company is dealing with the necessary redundancies pre-liquidation, and then you as liquidator are going to be selling the assets following appointment. If it's not going to be a sale by a liquidator, then you've got the risks for the purchaser that redundancies could trigger claims for unfair dismissal at considerably greater cost, potentially, than the cost of dealing with redundancies, and that the responsibility for redundancies and unfair dismissal claims could pass to the purchaser. And of course, that extra risk is almost certainly going to affect the price. So I think I've run through everything on the list now. I've gone over by 5 minutes. I do apologize for that. If there are any questions, please do ask them now. If there are points that interest you from this that you'd like to talk about, be very, very happy to chat to you on the phone or by email, whatever your preferred way of communication is. But thank you all very much indeed for participating this morning, and I hope to see you again next month on the 13th of December. Thank you very much, and goodbye.